Mr. Chairman, I have a couple of remarks I'd like to make.
Yes, go ahead.
First, as appellants cited in their brief, they cite to a 2011 case decided by a Virginia Circuit Court in which it states, it is an appropriate function of the board to reverse a decision of the zoning official where the board determines that the decision is contrary to the plain meaning of the ordinance and the legislative intent expressed therein. The board owes no deference to the zoning official in that circumstance. And then the court went on to find in favor of the BZA that had reversed a decision of the zoning administrator. And again, right now, I mean, the plain meaning of the 11-808, where it says text or map amendment, has to be interpreted plainly as a text amendment or a map amendment. We don't need to go into a parade of horribles about what if. We're deciding this one specific case. If we're concerned in the future that any proposed text amendment could be subject to this supermajority provision, all that needs to happen is that the city council needs to amend the zoning ordinance to explicitly state it just applies to map amendments. But right now, it says map or text amendment. It's very plain. I mean, the city has done a very good job of obfuscating the issue and said, well, it can mean this, it can mean that. But the plain meaning is the plain meaning, text amendment or map amendment. Moreover, I mean, the appellant raised the point that this text amendment is an effective map amendment in that whereas the height amendment had not previously applied to Zone W1, it now does apply. And so, again, I just feel that justice requires that the planning director's decision be reversed. I mean, we can reverse it on the grounds that it could be either a text amendment or a map amendment, or we could reverse it on the grounds that it technically is a map amendment, even though it wasn't called a map amendment by the city.